now cause number PD-0467-23, Jeffrey MERRITT McCUMBER versus the State of Texas. We'll give our guests a moment to leave. And everyone in the back is welcome to take a seat. Okay, you may proceed.
May it please the court, my name is Emily Johnson-Liu for the state. Permitting the outcry witness to testify over Zoom was proper here. The trial court heard evidence of the witness's intimidation in the form of death threats against her, family medical need to care for her injured husband, and that she had a conflicting court appearance. After that, the trial court stated it would find a necessity shown. Contrary to the Court of Appeals holding, this finding was sufficiently specific, and it was defensible. The denial, yes.
The lower court, did it, having looked at it, are they only saying that there was a lack of a finding and that's why they reversed? Or are they saying there was a lack of a finding but also that there was no necessity?
Both things.
Both of these things.
Yes.
If we think that the evidence supports a necessity, do we even care about whether or not there were findings?
I mean, I think that would be enough to reverse the Court of Appeals decision, surely, if you found it a necessity. I think maybe there's some confusion about what is enough to meet that test of being a necessity finding under Craig, so perhaps that it would be helpful, but not necessary. On the first point, though, on whether it's sufficiently specific, Maryland versus Craig and this court's decision in Haggard both say that a case-specific finding is necessary. But what does it mean to be case-specific? I think the Court of Appeals was wrong on this point. In Coy versus Iowa, which is the case immediately before Craig, there was just a legislative presumption that all children in sex abuse cases would need to have this different procedure for protection. And there was no finding in that case that these particular witnesses in front of the court needed that protection.
Well,
so that,
there was more to Coy than that. There was a screen.
Certainly,
yes, a screen. So
it was a different procedure than what we're talking about here.
Yes.
But as far as what does case-specific means, in that case, Justice Scalia's opinion said one of the problems there was no individualized findings that these witnesses needed the protection. You just had this legislative presumption. That wasn't enough.
And what did this court say in Gonzalez?
In Gonzalez, this court found situations where that you could overcome the need for full.
And find situations as in plural. It found the situation in that particular case supported the use of closed circuit.
That's right. But many other cases since then have found other circumstances of public interest that justify a procedure that's less than full confrontation. So where you don't have face-to-face, you don't have in-person defendant looking at the witness.
Counsel, go ahead.
So someone just saying, I'm afraid, I mean, I would assume a lot of witnesses that testify against a defendant are afraid, and that's enough or they can't make it that day is enough to override a defendant's right under the Sixth Amendment?
No, that just saying that you're afraid wouldn't be enough. And I think Romero, this court's decision in that case, supports that principle. But here you had other people acting against the witness, committing a crime of tampering or witness intimidation, retaliation. That is more than just a witness subjective fear on my own without anyone doing anything to me. I'm scared. That's not going to be enough.
What was that evidence?
The evidence was the testimony of witness Crawford. She was the outcry witness,
Okay.
and she testified to things that had happened to her, other people committing 3 burglaries against their house and driving by and making threats against her and her family, death threats.
I want to ask a question kind of in relation to that. Is there any sense in which the trial judge's decision to permit this procedure could have been justified under the doctrine of forfeiture by wrongdoing?
We didn't, because we did not connect it to the defendant.
Was it family or friends of his?
It was family and friends.
You don't
and
think there's an inference potentially there that maybe he's orchestrating things if it's his family and his friends that are
Well, he
engaging in the
certainly
conduct?
benefited from it. But I don't know that we had enough to meet the Giles threshold for forfeiture by wrongdoing. But I make the argument in the brief that it's sort of a comparison. Like forfeiture by wrongdoing allows you to have no confrontation at all, right? You have an out-of-court statement, you have no presence, no oath, no cross-examination. And that is allowed when you have evidence connected to the defendant. Well, maybe this is a situation where, even though we don't have that evidence of sort of estoppel, you created this wrongdoing. You're benefiting from this wrong act. We do have a situation where the witness is still intimidated to that same level, right? That she is so afraid to come to court for that. And so in that situation, it makes sense that one of those 4 protections we have in our confrontation would be not present. Another reason why it seems justified that there's a necessity here.
Counsel, I know that the state asked in the alternative for a continuance. Did the defense oppose a continuance?
The defense wanted the trial to go on forward without the outcry witness, yes.
Okay, so did they affirmatively oppose a continuance?
Well, they didn't say we oppose a continuance. They said, trial judge, you should allow the case to go forward right now without the witness.
Okay, thank you.
Counsel, if the evidence supports a finding of necessity, or actually, if the evidence doesn't support a finding of necessity, but we still don't have specific findings, does that mean the defendant is entitled to a new trial?
If you find there is, that there's no necessity at all
There was no
by the
necessity at
evidence.
all, but there was no specific findings. Is that a basis for reversing the court of, I mean, it's a basis for reversing the Court of Appeals, but is it a basis for a new trial?
If the trial judge was wrong, and we
The
never
trial
should have.
judge is right that there was no necessity, but they also didn't do specific findings.
And I think the trial court found necessity.
Yes.
Yeah, that's what I'm saying, but
Sorry.
I guess what I'm trying to get, I'm sorry, I apologize for not making this clear. It seems that deciding whether there is a necessity is a necessary thing in order to affirm the trial court. Right?
Yes.
Right. So it's not just about findings.
It's not.
It's not really going to be just about findings. We still have to determine necessity.
Right.
Okay.
If you find there's a necessity.
There's not an independent, I guess what I'm trying to get is it's this independent requirement under the Constitution that we should have a specific finding that in and of itself would require the trial judge to be reversed and give the defendant a new trial,
Well, I
regardless
think-
of the necessity.
I mean, I think the defense position is that it requires this, that you
Okay.
don't have the situation where you can allow confrontation or allow the modification of confrontation unless you have that specific finding. That's not our position.
All right.
Let me ask a question. If we subtract out the court date that the witness supposedly had and then the care situation with her husband, and we just have the threats, does the effect of the threats ever dissipate? Like, let's say the threats are made 6 weeks after the arrest, but then the trial is not till 3 years later. Like, does the time mitigate the harm of the threat? Like, should there be a temporal requirement that the threats have to be close to the trial?
I mean, I think theoretically there could be, if there's a really lengthy delay, but when you get back to trial again, that's when the intimidation, ratchets back up again. That is the very time when the witness needs protection. So I think even if there has been some dissipation over time, now we're coming back to trial. Now is the moment when you're going to be in the hot seat and you're going to have to decide whether you testify or not.
But wasn't the retaliation when she was in this state and then she moved because of that?
That's right.
Okay, so if they're using retaliation that happened near the actual.
Closer to the event.
Yes. And she moves, yeah, okay, if she has to come back, perhaps she's in fear. But as Justice before brought up, wouldn't that make a difference? I mean, she's removed from that retaliation that occurred.
She's removed from the events that happened, but I think there's still a good, objectively reasonable basis for her to have fear in that moment that the friends and family would again put her in a position where she was at risk if she was returning to Texas. And the trial judge was entitled to make that credibility call. Where you have a criminal act against the witness, that makes it an objectively reasonable situation for the witness to have real concerns. Even in the Craig case, Justice O'Connor was posing the question, at least an argument, that what do you do about a mob situation? That witness intimidation is a real concern.
Well, why not use closed circuit instead of Zoom? So she's not in the courtroom, but if you use closed circuit, then that would lessen the intimidation factor because she's not actually in the courtroom with the defendant.
I think in this case, it was part of returning to Texas as a whole that caused the concern. Being in
But that was the situation in Haggard too. That witness didn't want to come to Texas.
But the court found those reasons, that scheduling or inconvenience to the witness, certainly not enough to justify an infringement on confrontation.
But if you use closed circuit, you would accomplish removing her from the courtroom to be intimidated by the family or the defendant himself, plus ensuring that the right to confrontation was still there for the defendant.
I'm not sure what more will be gained in terms of confrontation by having closed circuit as opposed to Zoom.
Let me ask you this. Was the problem that she would be intimidated on the stand or that she would be subjected to more criminal acts?
That she would be subjected to more criminal acts. Within coming back closer to where the defendant's friends and family are, she would be subjected to more acts of intimidation against her.
And she had at least 2 more reasons.
That's correct.
Her husband had broken his back,
That's right.
and she needed to take care of him, and she also had a court date in Colorado or wherever she was.
Right. And so you had this sort of a totality the judge could consider in making that call.
And counsel, didn't she go to great lengths to try to hide where she was or where she went?
Yes, that's why the state had trouble finding her in the first place, to get her to trial.
So if there was a dissipation in criminal acts against her, it was because she'd left, or at least theoretically it was because she'd left.
It could have been, yes. And yeah, again, trial judge seemed to be reasonable in making that call. It's something that this court could rely on. As far as diligence goes, that's not always going to be a factor. Again, where the state acting more diligently is not going to affect the witness's ability to confront the defendant any further. It shouldn't make a difference. Factually, it wouldn't have here. Perhaps if the reason for witness not being present was only short-lived, then diligence could come in. But I think that's more of a factor of estoppel principles, like if the state created its own exigency. Unless there's any other questions, I've reserved some time.
Thank you, counsel.
Good morning. My name is Steve Greene. I was appointed to represent Mr. McCUMBER. I need to start off by admitting I have an error in my brief. When I first did the initial brief before the Court of Appeals, I misread the clerk's record regarding the number of previous trial settings. There was only one previous trial setting. I realized it yesterday when I was preparing for today.
Thank you.
Next, first I would like to say that as I read the cases of Haggard and the other cases that were cited by Haggard, the case-specific findings are required.
Counsel, was there an objection to the lack of case-specific finding?
The trial counsel, his objection was Haggard. Haggard specifically says the case findings are required.
So he objected that the findings were not, I mean, there was a finding of necessity, it just wasn't specific. Was there an objection to lack of specificity in finding?
Not in those words, but I submit that the trial judge was given the Haggard opinion.
Mm-hmm.
The Haggard opinion specifically says case-specific findings are required. Not only did the defense counsel cite some of the factors that were mentioned in Haggard, the state even tried to clue the judge in that the case-specific findings were required. If the trial judge isn't going to listen to y'all, I don't think he's going to listen to a solo practitioner who's already brought up Haggard and what Haggard requires. And it's clearly in the opinion that case-specific findings are required, and the state pointed that out in the argument on the preliminary hearing. The main reason or one of the main reasons I submit that case-specific findings are required is because it's my position that the circumstances of the witness should not be the only factors to be considered. And this court in Haggard did also consider the state's lack of diligence in Haggard, and I submit the same problem is in this case. Even though there were not two trial settings before the final trial setting, there was one trial setting that was in February, it was set for trial in March, and I know the clerk's record is not specific that both sides announced ready, but there was no motion for continuance filed by either side, so I think it could be presumed both sides were ready for trial in March. We're talking 3 months before the case finally went to trial. And no attempt to contact the witness was made until a week before trial. And this is after the case was finally set for trial, April 20th. The state didn't issue their subpoena applications till a week later. So you've wasted 7 days there. They get their subpoenas on the 28th, another wasted day. They don't give the subpoenas to the investigator till May the 2nd. That's 4 more days, well, 3 or 4 more days. You're talking about 12 days they wasted, not doing anything to try to locate any of the witnesses for that matter. But, I mean, this is a situation where, especially if you have announced ready for trial on a previous occasion, I think it's, sure, you may not be the number one case. I know it was a rare circumstance when I was prosecuting that I knew exactly what case I was going to be handling. It takes a phone call to find out if the witness is still around. I mean, if you get a disconnect message on the phone call, you know you got a problem. You need to do some further searching for the witness.
Let me ask a question. If the threats are substantial, or whatever word you want to use for we're sure that they were threats, does the diligence even matter?
Oh, yeah, I believe so, because, first of all, well, I dispute that the threats were legitimate, or that her fear was legitimate. The reason I dispute that is because here she not only claims that she was afraid of McCUMBER and his family and friends, she says she don't even trust the state to get her to and from court. It would have been a simple, they put her on a plane, she gets on the plane, flies to Houston, DA's office picks her up in Houston, takes her to Polk County. She does her testimony, they take her back to the airport, she's back on the plane to Colorado. There's no way anybody can hurt her. And also, her allegations were not supported by any complaints that she ever made to law enforcement about these supposed threats or about these supposed burglaries that were somehow connected to McCUMBER. I submit that if you're going to believe someone's been threatened, there should be some corroboration of those threats, especially when the witness is saying, not only am I afraid of him, I don't even trust the state. I'm afraid of the state. It doesn't make sense. But if you're truly afraid, you don't just volunteer your full address when you're asked your location. Right off the bat, when she's questioned, where's your location? She didn't say Colorado or Pagosa Springs, Colorado. She said 543, whatever the address was, in Pagosa Springs, Colorado. If you're really afraid of somebody, and that's why you left Texas, they can get in their car and drive to Colorado and hurt you or kill you.
Counsel, are we allowed to look at this record and try and second guess a trial court's determination about whether this person was really afraid?
I'm sorry, I missed.
You're saying, like, you're giving examples of why it is she shouldn't be believed that she was afraid, but the trial court found that there was a necessity. Shouldn't we end up deferring to the trial court on whatever factual determinations that were made?
Not when the trial court even didn't think Haggard applied to this case.
Well, it did make a finding. It just didn't make one specific enough for you.
Well, and that's true. I mean,
Right.
but that's the whole point. Whole reason for case-specific findings is because not only should there be findings as to the circumstances of the witness, there should be findings regarding the state's diligence or lack thereof.
Right.
I mean, they created the emergency by not locating her earlier. They didn't find her until the day after jury selection. And I believe a question was asked earlier about the continuance. The jury had already been sworn, so jeopardy had attached. Now, you have continuances and you have continuances. I mean, if they reset the case for another week for the state to have gotten her to Polk County, well, you may still have problems with the current jury that you have. But if they're talking about trying to get a totally new jury, jeopardy had already attached. They were going to be out, they were going to be poured out of court if they had done that. But also, I submit in my brief also that besides the state's diligence or lack thereof, that we're talking about the trial courts have control over their proceedings that occur in their court. This is taking away that control because, and I know there was one previous trial setting, there are any number of times that you have cases that get reset and reset and reset for trial because of the volume of cases. But if you don't require some diligence on the prosecutor, you're basically leaving it to the party, to the state, to say, well, I'm just going to wait till the last minute to find these people.
I guess one of the things I would ask you, though, is what are the parameters that we should be utilizing to try to determine when diligence is enough? Because there's some evidence of looking. You're arguing it's not enough, but the state is arguing there was an effort that was made to look for the person. They did their best. So what are the parameters that we should be using to determine whether there's due diligence or the state exercised due diligence to find the person?
Well, it's like I said earlier, if you have a case, if you have a situation where a case has been set multiple times, okay, the first announcement already, Sure, they don't know everybody is available at that time, but once you announce ready for a case, for trial, it takes a phone call. You know, your witness statements are going to have contact information for the witnesses. Make a phone call.
How does the defendant's right to confrontation fit in with the parameters that we're looking at overall for this case?
Well, a person who is not in the courtroom to testify is not under the same tension, or if you want to call it stress or whatever, that the average witness is under when they are actually in the courtroom. There is some tension when a person testifies in court. When they are 700 miles away, or 800 miles, whatever it is in Colorado, and I know Ms. Crawford did not exhibit this characteristic, but her husband was in the background making all kind of comments, calling the defense counsel an idiot, you know, making all kind of.
But counsel, that was not for the trial purposes, right? Because she was instructed to go to a government office
Right.
for the actual testimony at trial.
Right. What I'm saying is that if it had been the husband instead of her as a witness, and this could be any witness in any case who exhibits characteristics, we've all had witnesses who just won't stop talking, you know, and when they're 1,000 miles away, you're in a lot less, a lot worse condition or situation trying to control them than if they're right there in the courtroom. The judge can hold them in contempt.
I see what you're saying, and the point is well taken about having the person in being present there for a cross-examination but is that really part of what we're here for? Isn't that sort of the second, aren't we really only here about the necessity for the person, not necessarily whether the proceedings that they had were adequate in order to ensure that it's really just about whether or not they could utilize the procedure?
Well, yeah, I mean, we're basically here, we're here about the necessity.
Right.
Okay, but like I said, I think part of the necessity finding should be based on whether the state was diligent in locating their witnesses.
Right.
And then after you make that determination, and you also determine if the witness is controllable on the stand, then you consider, are the witnesses' fears or situation sufficient to justify infringing on the defendant's Sixth Amendment rights? And in this case, I believe Romero was brought up earlier. Adults are expected to be, I think the term was sterner stuff than children. And also, I submit that for a witness to be justified in their fear, especially in this situation, if she had all these problems with people making threats, if she had all these problems with burglaries, you normally report it to the police so the police can investigate and hopefully catch the people. There was no indication she did any of that. She claims to just, head for Colorado. And it's like I said earlier, if you're really in fear of somebody, you're not going to volunteer your address. I mean, you say, I don't want to give my address, I'm not going to give my address. You just don't blurt it out.
So are you inferring that her fear coming to trial, coming back to Texas, was based on speculation as to what would happen in Texas?
I think it's just a way out. She don't want to, I submit, people don't want to travel hundreds of miles. Well, they don't want to go to court if they're in the county where the trial's taking place. But if they're 1,000 miles away, they sure don't want to make that trip, especially when she claims to not even trust the state. There's no reason for her not to trust the state. Nobody from the DA's office was going to harm her or let her out of their sight.
But did she, whether she had proof that she was being intimidated or threatened or burglarized or whatever, when she was in Texas and she moves to Colorado, was there testimony from her or somebody else that she was also intimidated or in fear when she returned to Texas to testify?
Well,
Or is it all based on what happened before she left the state?
I believe only her testimony on that was that she didn't trust the state to get her to and from. I believe that's all she said on that issue about getting to and from court. Now, the issue with her husband's back, this is another situation where diligence comes in. If the state had found out where she was weeks, if not a month or so earlier, they could have made arrangements. They could have had a home health care worker, they were going to pay for her to fly to and from Colorado to testify. They could have forked over a couple of $100 more to hire a health care worker, if necessary, to watch him for a day or two that she's in trial. And then her court case was a 10-year-old case by her testimony. I mean, it's 10 years, been pending 10 years, a few days more. The state had already made arrangements for her to testify in a remote room or, a room at the courthouse, apparently. The state, I submit, could have made arrangements to reset her case for a few days when you consider it was 10 years old already. But the fact that the state was not diligent in locating her complicated all that, because it's obviously easier to do that kind of thing when you have a few weeks' notice as opposed to a day or two notice. If you don't have any other questions, I'll give you back.
I would like to ask one more question, what's the appropriate remedy if we find that the trial court's findings were insufficiently specific to the facts of this case?
To affirm the judgment of the Court of Appeals and send it back to the trial court for a new trial.
Okay. You don't think that there's some way that we might ask the trial court to, after the fact, make findings? We do that kind of thing sometimes when, for example, in competency cases, trial judges can go back and make a sort of post-trial determination of competency at the time of trial. Is something like that
Motion to suppress.
possible? Would it work? Is there a reason why it wouldn't work?
Well, it's my position that y'all have the facts before you. I mean, yes, you can do that, obviously, but it's just creating another delay in the litigation. I mean, I think about 25% of the trial record was devoted to the hearing on whether she was going to be allowed to testify by way of Zoom. And I submit that the findings could be made by this court rather than waste more time and resources sending it back to the trial court.
Thank you, counsel.
Thank you.
This is not a situation where we should be overly concerned that every witness is going to claim the kind of fear that the witness was here. You can require an objectively reasonable set of circumstances. You can require acts of criminal conduct against the witness and evidence that the trial judge believes. But that's ultimately where you begin to construct this necessity, is what did the trial court, what evidence was there and what could the trial court have believed? It's trial court's prerogative to decide these questions, and when the witness was asked, do you have any illness or other ailments that would prevent you from returning to Texas? And she said, nothing other than the fear of death. Seems to indicate that she's worried about coming back to Texas because of the intimidation that these criminal acts that have been perpetrated against her. And if that is not what happened, it's really incumbent upon the defense to ask for those additional findings from the trial court.
Counsel?
Yes.
I'm glad you mentioned that. So if there's a lack of objection to more specific findings, why don't we just look at the evidence in the light most favorable to the trial court's ultimate finding?
We do that,
Right.
yes.
Yeah, I mean, like we do that in Cullen, or we could do that in, like, any motion to suppress. If they don't ask for specific findings, we just sort of look at the record in the light most favorable to whatever the trial court ruled.
That's right. And here that would mean that trial judge credited all of her concerns, and that this was not just speculation, that she had a real basis for having fear of returning to Texas. And that, staying in Colorado, moving to Colorado in the first place, gave her that protection. She was able to testify while still in Colorado without having to be subjected to whatever additional conduct might happen against her. It really was incumbent upon the defendant to ask. He didn't. Therefore, the usual state law presumptions apply. We don't have a constitutional right to these subsidiary factual findings. And certainly where he doesn't ask for any, then we're left with the usual appellate presumptions.
Can we consider that there was an alternative available to the state, like I spoke of before, like closed circuit, to accomplish both things? Taking care of her fear to testify in front of the defendant and upholding his Sixth Amendment right? Can we consider that there was an alternative to this?
It wouldn't be determinative. I mean, consider it, but Craig especially says that there does not have to be a consideration of alternatives like there is in the Waller v. Georgia context. So there you have other protections other than just the two parties to be concerned with. So perhaps there's greater reason to consider alternatives. But Justice O'Connor's opinion says you don't have to do that.
When the Supreme Court says, so the Supreme Court has addressed this situation in the context of a Sixth Amendment argument, right? Somebody's preserved a Sixth Amendment claim. And they say that these specific findings are required. Are we at liberty to say, yeah, the Supreme Court has said they're required, but if somebody doesn't object to the lack of those findings, you see what I'm saying? Do they have to preserve the Sixth Amendment claim and the absence of the findings when the Supreme Court said you have to make the findings? You know what I'm saying? I'm trying to
I think
figure that out.
Yeah, when a defense attorney objects under Craig, says confrontation, they have preserved the right to get a finding of denial of face-to-face confrontation is necessary for important public interests. They are entitled to that. Okay, but that was the finding here when trial judge says that is, I'll make a finding of necessity here. Implicit in all of that, just like there is in Lively, that this is what the trial judge was deciding. The parties all pitched this. You got to consider Haggard. It has to be case specific. The defense attorney talked about there has to be important public interests. Trial judge knew that was what was being decided and made the express finding, I find necessity here.
But here's my overriding, right? I'm thinking sort of past that and only academically, okay? In the sense that if the court finds that finding that the trial court made isn't sufficient under the U.S. Supreme Court's view, are we at liberty to say, yeah, but nobody objected, so to the lack of more specific findings, so they waived that? Are we allowed to do that, or are we stuck with, if there was no findings, got to reverse?
Well, you could abate for findings. I think that would be the more limited, tailored to the violation. If it's not specific enough, send it back to get that specificity. But I think if indeed it's constitutionally required that you have some sort of finding, I don't think Texas law could trump that. What I'm saying is that these are the sort of elements that make up the broader finding of it is necessary to invoke inhibit some of his confrontation rights, that's necessary. The elements that make up that claim don't have to be expressly said. And if you need the fact findings that would determine all of these subset elements, then ask for those. That is what's going to be controlled by state law. Craig requires that finding that a denial is necessary.
So if we're supposed to look at the cases, each case on its own, but we decide, let's say we decide to go with your approach that this general necessity finding is sufficient, then how is that going to work in the future as far as case specific? Because from now on then, anybody just says, I find necessity is enough. That's not necessarily case specific. That's pretty broad.
Okay, so you still are going to have to look at the context of that case, right? If there's no hearing, there's no evidence, and the trial judge certainly, if the parties are not talking about what's required in this necessity finding. But once the parties talk about this and a trial judge then shorthands to, I'll find the necessity shown, then that pulls back everything that's happened before then. So I think, and that's, I think, what Lively is talking about. That was another case, and I see I'm
Please
out of time.
finish your.
So in Lively, it was about videotaped child testimony, and the trial judge did not make a specific finding that it was the presence of the defendant as opposed to in the courtroom that required this different procedure. And this court held that just saying that it was the psychological needs of the child warranted the procedure. You didn't have to do all those elemental findings of each.
And let me just, I know Zoom, closed circuit's been around for years, but the Zoom is relatively new. Are there any other cases outside of Texas that have had to deal with this issue of using a Zoom process for a witness? Because they're clearly different. And in my mind, they're different as it relates to confrontation. And has anybody else used it, as far as you know?
I do believe there are other cases. I'm not sure they are using Zoom as opposed to other technologies, but the federal courts have used telephone conversations, in addition to closed circuit. So I'll have to research this a little bit more to tell you.
Okay.
Thank you.
Thank you, counsel. The case is submitted.
All rise.